My name is Nomfundo Jele from the Law Society of South Africa. I'm joined by Carol Selepe, who sits on the Law Society's House of Constituents, and we'll be discussing the Divorce Backlog Project. The purpose of the project is to fast-track unopposed and selected divorces to get finalized, and to fast-track opposed divorces through the possibility of mediation. This video will focus on the topic of pension fund interest in divorce matters. Hello, Carol, and welcome.
Good morning, Nomfundo. How are you?
I'm fine, thanks. And you?
I'm well, thanks. Thanks.
Okay, Carol, is pension interest important in divorce matters?
Definitely, Nomfundo. Yes, pension interest can be quite a substantial amount of money. And you see, in terms of Section 7, subsection A of the Divorce Act, it provides that in determination of the patrimonial benefits to which the parties to any divorce action can be entitled, the pension interest to a party shall, subject to the provisions of paragraph B and C of the Act, of course, can be deemed part of that person's assets.
Okay. And Carol, is it possible that a divorce matter can be delayed because an attorney has not properly set out a claim by his or her client against the pension interest?
Yes, Nomfundo, it's possible. In Section 7, subsection 8 of the Divorce Act, it provides that notwithstanding the provisions of any other law or of the rules of the pension fund, the court granting the decree of divorce in respect of any member of such a fund may make an order that any part of the pension fund interest of that member, which may, by virtue of subsection 7, is due or assigned to the other party, that is the other spouse, to the divorce concerned, shall be paid by the fund to that other party when pension interest accrues to in respect of that member. So what this means is that a decree of divorce issued by a court on pension fund interest is discretionary. It is not compulsory, Nomfundo. So if a party claims pension interest, and if the court grants such an order, the process will not be delayed because of this.
Is it necessary that a claim in regard to such pension interest be specifically pleaded in the divorce paper?
So yes, Nomfundo, it is advisable that the pleadings must contain such a claim, keeping in mind that the courts recognize that it is an extraordinary power to make an order binding the pension fund, which is not party to the proceedings, meaning that the pension fund will not be party to the divorce action. So a court will not ordinarily exercise such a discretion unless requested by a party to the divorce proceedings in court.
If no pension interest has been claimed by the non-member, is he or she deprived of his or her share of the pension interests?
The challenge with that is that, Nomfundo, if an order has not been granted in favor of a non-member, he or she will be unable to enforce it against the pension fund. There's a case law, it's a 2016 judgment in the Mpumalanga division of the High Court. It's M versus M under case number HCA 18 of 2015. In the High Court, it was ZAMLMPPHC 2. It was decided on the 17th of June 2016. In this case, it was concluded that an omission by a court in divorce proceedings to award a non-member spouse 50% or any portion of his or her member spouse's pension interest does not amount to an order of forfeiture by a non-member spouse of his member spouse's pension interest. However, an order in terms of Section 7, subsection 8A is required in order to enable a non-member to compel the pension fund to pay his or her portion of the member's pension interest to him or her.
And just finally, Carol, what remedy, if any, is available to a non-member spouse in such circumstances?
The non-member will have to file a claim against the member. This process will involve additional costs. It will involve additional time, and it can be avoided if a party specifically can request that the court grant him that order.
Okay, thank you. Thank you so much, Carol.
Thanks, Nomfundo.